All right, welcome back. Welcome back. I've got a fun one today. Hopefully this works. I've had audio issues, which is one of the reasons I haven't done court videos in a while and just done docket readings, legal filings, because I can either hear myself or I can hear the video. For some reason, my microphone audio input doesn't work. I screwed up a setting somehow, so here we are. But either way, this is a very important, very educational video. And for those of you who don't know me, who haven't been here before, I'm Joe. I'm an attorney licensed in the state of Utah. As you can see by my authentic Moroccan fez that my parents bought me in Morocco, that I mean business today. And I I've got to give sovereign citizens their due. They were right all along about one thing and one thing only, but they were right. They often say, "Oh, you're speaking legalese, that doesn't count," and they hate legalese, but they were right. They were right. Legalese is a magical incantation. And it's a secret but required class in law school. You have to take it every semester. My legalese classroom was right next to the potions lab. It's that serious, that magical. It's just it's what we do as lawyers. And I got an A in every single semester of legalese, so I'm an expert. I might even start teaching it soon, uh, if any universities want me. But at great risk to myself, I'm going to peel back the curtain and I'm going to translate the legalese from Judge Slavens so that all of you, and especially the sovereign citizens, can understand what he's saying. Because the legalese is tough. I get it. I get it. Not all of you have had 3 years of law school legalese to understand. It's tough, but I'm going to translate. And it's a great risk. I'm the American Bar Association, they do not like this. They're going to come after me for this video for peeling back this curtain. So, just be aware of that. Pray for me. It's going to be a rough go, but I'm willing to do it. So, here we go. So, little background. This is a video. It's made the rounds. I'm taking it from Old Squishy Gardener. He's great. Obviously, subscribe to him. He puts out great stuff. And this is in Michigan, in Judge Mark Slavens' courtroom. Slavens, not Judge Slaven in Taylor, Michigan. This is Calhoun County, Michigan. I believe this is a circuit court, so higher level. And this sovereign citizen has been sent for competency evaluations, and they're back. Spoiler alert, she's competent ish. So she's trying to get rid of her lawyers, and here we go. So, and then, little spoiler alert at the end. I'm not going to play it because it's not a very exciting hearing, but there was an update today, and I'll summarize the legalese from that as well at the end as a little bonus. But it's really it's not worth watching for the amount of time it takes. But let's hit play, and hopefully the audio works.
Ma'am,
So
no,
what-
you don't get to quiz me.
It's my right to ask questions.
Ma'am, don't interrupt me. I don't interrupt you. You don't interrupt me. All right, you can call Ms. Tubbs' case.
Okay. Following case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P 36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
So the legalese for that, this one's pretty obvious, but it's you're going to sit in jail longer if you don't agree to waive. So
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yeah. Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Sean.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Sean.
Okay, then it says at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Sean.
Yes, Your Honor.
And the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
all right. So to summarize that, it's she was sent for competency hearings. An evaluation. Sorry, this is the hearing, but she was sent for a competency evaluation to a psychiatrist, psychologist, whatever, and they found her competent to stand trial. Now, there is another question that needs to be asked, and that is she competent to represent herself? Because that is a separate issue that they're kind of glossing over. But that's okay, because it's more entertainment for us. You know, if she's competent for trial, she's probably competent to represent herself, because it is a fairly low bar. And so, you know, everyone stipulates it's basically, are you just going to let me do this? Are you just going to let me put this in the record? Is the legalese for that? Like, I dare you to try me. And then, is she taking medication? The judge asks. The legalese translation for that is she's competent, but is she still crazy? Like, are we going to have problems with her mental health? Because frankly, competency for trial is a low bar. It's you know, are you able to assist in your defense? Or do you have the ability to understand the charges being brought against you? Can you comprehend it? Can you comprehend you know, I don't even know what the charges are in this case, actually. I think that's in an earlier video that we're not doing today. But, you know, does she have the ability to understand that, you know, the elements of DUI are, she was in actual physical control of a vehicle. She was actually impaired, yada, yada. Doesn't have to agree with it, just has to understand those are the elements, and that's what the prosecution has to prove. So, but is she on medication? That's legalese for, are we still going to have behavioral problems in the trial, even though she can go to trial?
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No, ma'am.
Translation for the surprised no medication? You sure you're not crazy?
Counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not.
Okay, translation for that. Asking the attorneys, is this bitch lying?
Not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What day?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor,
So, couple translations there. March 17th, wear green. That's legalese too. St. Patrick's Day, wear green. Otherwise, in elementary school, you get pinched if you don't wear green on St. Patrick's Day. In court, the legalese is you better wear green, otherwise you might get a bench slap. It's that simple. And then, what was the other question? What was the other question? Sorry, I need to go back just a second.
9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor,
Okay, yeah. Has counsel had a chance to discuss whether this is going to be resolved or not? Is, the legalese. Are you going to waste my time going to trial, or have you discussed a plea deal? That's what that means. That's the legalese.
I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under code UCC 1-207.
Okay. I know I said I'd translate the legalese from the judge, but the translation of what she just said is blah, 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 because it's gibberish. It's absolute nonsense. There is no compelled benefit. There is no contract. This is not a commercial agreement. This is a criminal trial. You're speaking gibberitic nonsense.
I have the rights to represent myself and waive all counsel knowingly, willingly, and intelligently. And I would like to.
Right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
Translation from the judge. Is she serious? Really? You think you can do this? You think this job's easy? I'm skeptical.
That's correct.
All right. Well, then I'm gonna voir dire you with regard to that decision.
Translation. I'm gonna ask you some questions because I think you are making a huge mistake, and I can't give you legal advice, but through asking you a few questions, I'm gonna try to convince you not to do this. It's a bad idea.
Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, once I get that, then if she wants to represent herself, then we can.
Well, here's
So this is actually kind of an interesting legal question. So the defense counsel says, whether I represent her or not isn't even at issue here yet because the court hasn't yet decided that she's competent to stand trial. If she's not competent to stand trial, she's not competent to represent herself. So she's not competent to waive counsel. If she's not competent, we can't proceed. She needs to be, institutionalized until she can be restored to competency, or she needs to, be released and have her charges dismissed. Now, I actually, like I said, we're watching Old Squishy Gardener's video, and he throws his written comments on the video. And a few minutes ago, he said, I think every sovereign citizen should have a psychological evaluation. And I disagree. If I were a lawmaker, I'd actually pass a law that, the sovereign citizen, having sovereign citizen ideology in and of itself, it's poor decisions, but it's not incompetence as far as legal responsibility. And so the judges need to stop entertaining this nonsense because that's all it is. And so the question is here, if she is not competent to stand trial, does she have the ability to say, you know what, I'm competent no matter what you say? It's these lawyers that say I'm not competent. I'm competent. I never agreed to go through the competency evaluation. Let's keep going. And so to me, that's a interesting question. If you're not competent, can you waive the non-competence? And that's something I don't actually know, but I think that's what this defense attorney is trying to establish, is like, we need to know first. We need a ruling from the court first, whether she's competent or not. And then we, depending on what the court rules, we're skipping a step here. But Judge Slavens is kind of like, well, she's waiving, so let's move on.
Ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
That's defamation of character. I will not be doing any of that.
So it's not defamation. It's, number one, this is a court proceeding, litigation privilege. We've discussed this in other cases that we've done, Ashley Giard, the TikTok psychic, trying to sue Professor Schofield's attorneys saying, hey, you've defamed me through your legal filings. And no, because legally that cannot be defamation. Here, number one, they're not asserting that she has a mental infirmity. They're saying, Your Honor, we have concerns that she has a mental infirmity. Can we have her evaluated? That, to her, that might not mean much, but that is a huge difference, because one is saying, Your Honor, she's crazy, as an affirmative statement. The other is a statement of opinion saying, Your Honor, we have our concerns based on her behavior. So, but once again, it's litigation privilege, so it doesn't matter anyway.
And I would like to
You do
exercise.
not want, you are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding.
Translation, you sure you're not crazy? I think you might be, but the professional did say you're competent to stand trial, but you sure you don't want to at least talk about it a little bit? Because I might find you crazy because it's my decision. You sure you don't want to do that? And if it's a minor crime, you'll just get out.
Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Sean.
So, ma'am, I'm gonna have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not gonna do it, but I just want you to talk with him and understand some of the risks of doing this. And
the legalese translation is, I think you're making a poor decision. I want this attorney to do his damnedest to talk you out of making that poor decision. Let's see how it goes.
okay.
Your Honor, I understand all the risk and I do not wish to talk to him. I have not talked to him in 6 months, so why would I need to talk to him now? Thank you. I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him, is that correct?
Translation, seriously?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're gonna need you to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions, just so you understand. Can you swear her in, please?
Okay, so basically it's, the attorneys, they were sworn into the bar. We're sworn in. We're officers of the court. We have an obligation not to lie to the court, period. She hasn't taken an oath. She hasn't been sworn into the bar. So he's going to do it right here, right now.
Ms. Tubbs,
Well, or try.
please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I
can
am
affirm.
here to, I'm here
All
to
right,
reserve
let's
my
have you
right.
raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm?
Okay, I have an issue with this. Judge Slavens, just do the damn thing yourself. If your clerk is struggling, do it yourself. You can do it. Judges can swear in parties or witnesses or whatever. It's, most courts, it's traditionally either the clerk or sometimes it's the attorney, depending on what you're doing. But the judge can. Lots of judges do. We see it with Judge Simpson often. Of course, Mr. Allen does it too. But if your clerk demonstrates she's not quite sure what you want, do it. Do it. Just do it. Take away the uncertainty, the awkwardness, the waste of time. Just do it.
Affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's
I
do
do
it
not-
again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you.
Translation. You know, raising your right hand, it doesn't mean anything. It's tradition, but it really doesn't mean anything. But here's the translation. If you're not going to follow this instruction, if you're not going to follow this rule, I don't have confidence that you are going to follow any instruction. I don't have confidence you will follow any court rule. If you don't give me this one little bit of confidence that you are capable of following rules, we're done. You're keeping your attorney because you forfeited your right to self-representation. That's the legalese translation there.
All right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not
But I need to
having
know
you
what
present
oath,
yourself.
what oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right, well, let's have her raise her hand again and you say the affirmation. It's not an oath, it's an affirmation. Raise your right hand, please, ma'am.
I wish you could charge sovereign citizens for the time they waste in court. These semantic games are a waste of time. I'd be held in contempt. I'd be held in contempt. She wants to play this game. I'd say, you know what? I'll see you tomorrow or the next open court date. You want to play semantic games? You're not going to waste the court's time. We're just going to move on. We can try again later when you're more amenable to following the rules, to not playing semantic games.
Do you affirm?
No, yeah, okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary of firm.
All right, thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes,
Translation, please take the lawyer. He's free. He knows what he's doing. Please take the lawyer.
sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
Translation, he's free.
I waive that right.
Huh?
I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay.
Translation, I don't think she can afford a lawyer. We're expensive. And if she could afford a lawyer, she'd be out on bail already.
What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
Translation. What's the maximum sentence so we can scare her into taking the attorney?
Punishable up to 5 years or a
It's-
fine not.
Ma'am, just wait. Let me speak, okay?
Translation. You're not the damn prosecutor. Your name isn't Madam Prosecutor. So shut up. Shut up. We know you're Miss Tubbs. I was speaking to Madam Prosecutor. I didn't ask you, so don't talk.
I'm
Madam
sorry.
it would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year.
Ruh-roh. Ruh-roh. The defendant doesn't know what she's talking about. She doesn't understand, well, anything, but she doesn't understand that, yes, carrying a concealed firearm without a license is a 5-year offense, maximum penalty. But, as the prosecutor is about to say, there's an enhancement because she's a career criminal. A lawyer would know that. A lawyer wouldn't have said 5 years, talking out of turn. But she's not a lawyer, so she didn't know about the enhancement. Good thing Madam Prosecutor does.
Year maximum penalty, but there is a habitual second offense notice, so that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5 years.
All right, ma'am, the maximum possible sentence in this matter is 7.5 years because you are a habitual offender second offense notice. So it's
Translation. If you're a pain in my ass through the trial, you're getting 7.5 years.
7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
Translation once again. Please take the free lawyer. It'll make my job so much easier. And your result will be much better as a consequence of my life being easier.
No, I would like to represent myself and put in the motion to dismiss.
Okay, so ma'am, first of all, can you give me your educational background?
Translation of that, okay, was I don't take oral motions to dismiss. Put it in writing. Follow the damn rules if you want to play lawyer. But what translation for what's your highest level of education? You're being really, really, really dumb here. Are you sure you finished kindergarten? Now, of course, this is part of the Feretta inquiry, so this is required. But even within the Feretta inquiry, the Supreme Court case, Feretta versus California, is in legalese. It was written by the Supreme Court. So it's in legalese. So it still needs to be translated. So even in Feretta, in the Supreme Court opinion, it was, you've got to ask, are you dumb? Are you sure you grew out of eating paste in kindergarten? So
I
How
have
far have you gone in school, ma'am?
college.
College, okay. And
college, okay. Translation. I do not believe you because you are acting so dumb that I don't see how you got into college. But even if you did, that college deserves to give you a refund because they failed you. In fact, whatever college you went to should probably be investigated about the continued existence of its the dumb is rubbing off on me. The accreditation. See, I know big words, but the dumb is rubbing off on me from Miss College over here.
And have you represented yourself before?
Yes.
Translation: you're a criminal. You've got the habitual enhancement. So is that previous conviction one that you did yourself too? Because you didn't do a very good job.
And why do you wish to how many times have you represented yourself?
Twice.
Okay, and then what were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay.
Translation: I don't believe you. You've been convicted before. You don't know what you're doing.
And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
Oh. So you say you've represented yourself twice, and one was a criminal case. But then number 2 is also a current criminal case. And today's hearing that I'm going to summarize at the end actually revealed that criminal case, she's guilty. So she lost that one. And it's set for sentencing because in today's hearing, they tried to set the trial or pre-trial or whatever, doesn't matter, for a certain day. And she said, nope, I've got court in that other county for sentencing. I don't remember if it said she pled or if she went to trial. I'm assuming she went to trial and lost.
Mr.
And you're
Mayor.
representing yourself in that case?
Yes.
Translation: good luck.
And why do you wish to represent yourself in this case?
Translation: amuse me. Amuse me. I want to hear a funny story about why you want to do this.
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract.
Another translation from the defendant. Wah, 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 durr. Trade Secrets Acts? Well, no. And you're not entering into a contract. This isn't commercial. The court isn't suing you. The court isn't suing you. That's the court isn't a party. It's a referee. But the prosecution isn't suing you. They're prosecuting you because this is criminal, not civil.
You all as owning our vessels, and I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
That is frustration. In order, and translation, tell me the elements of this offense. in order to defend yourself, you have to, well, either hope the prosecution doesn't cover all of the elements of the case, but then if the prosecution fails, you still have to get up and make that motion for a directed verdict and say, Your Honor, they forgot this element, so you've got to acquit. So you've got to know the elements. Or if you have to put on a defense, you've got to know the elements so that you know what to attack. Because what is not going to be successful is, Your Honor, this court is an admiralty court and the fringe on the flag. Yikes! Because that's not an element of the crime. She's going to be focusing on nonsense and ignoring the actual elements of the crime. So the judge wants right here, right now, ma'am, do you know what you're going to have to defend?
The elements of this offense is that it's punishable by imprisonment
No.
for more than
No,
5.
that's not what that's not
Oh.
what the elements of the offense are.
The elements,
Translation. You have absolutely no clue what you're talking about. Stop. Get the free attorney. He's free. He's right there. He's in the courtroom, ready to help you. He's seen the evidence. He has discovery. He's ready to go to trial. He knows the elements. It's going to be something like had a firearm in their actual physical control, wasn't allowed to be in actual physical control of the firearm. You know, I don't know exactly how it's worded in Michigan, and if it's, you know, unlawful carry of a firearm by a felon. So then the element would be has a specified felony conviction. You know, if it's concealed, you know, they had actual physical control and the firearm was concealed and they didn't have a license and yada yada. So those are the elements. Now, the punishment is important, but the punishment isn't an element that is proven to the jury. Because frankly, the jury isn't allowed to know what the punishment is, except in capital cases. Well, some states are weird. Like, I believe Texas actually lets the jury sentence the defendant. Like, most of the time in most states that aren't Texas, and even in Texas, it's not automatic. The defendant chooses jury sentencing, but usually it's just the jury decides the prosecution has met all the elements, the defense hasn't poked holes in those, hasn't presented an affirmative defense, so guilty, and then it's off to the judge to sentence. The only thing most juries decide on sentence is death or life in prison. So only in capital cases in most states. This not being a capital case, the range of punishment, the maximum punishment, is not presented to the jury at all. It can't be. It can't be. Frankly, if she brings it up, it could be a mistrial.
what do you mean
Yeah.
by elements? Because you know, y'all
Well,
use
that
double
see,
language.
that's the problem. You
Y'all
don't
use
know.
double language here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense?
Translation. You don't even know what the hell you're doing. Just stop. Get the attorney. Like, this is basic stuff. Basic stuff. And you don't even know that.
How are you gonna do that, ma'am, if you don't even know what you have to defend against?
I have to offend against the accusations, the charges.
Right, ma'am, tell me what the rules do you know the rules of procedure?
The rules and procedures to this.
Do you know the rules of procedures? Not the rules and procedures, the rules of procedure. So the local court rules and the rules of criminal procedure. And frankly, the rules of evidence as well, because that's kind of procedural, but it's evidence because, but, do you know the rules of procedure? Do you know how to present evidence? Do you know how to do a trial? Are you just going to be a fatal hemorrhoid on my ass by not following the rules through trial because you can't be bothered to look up what the rules of criminal procedure are? Because that's going to be a problem.
Is that, yes, that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct.
No, they're not going after your corporation. They are going after you. They're not going to put your corporation in jail. They're going to put you in jail. They don't take the articles of incorporation and put it in jail. They put you in jail, and they're not suing you. They are prosecuting you. But this isn't the rules of procedure. It's not the rules of procedure. It's just the absolute basics of what's going on. This is Marvin Gaye. What's going on? Sorry that I realized that was painful, but the rules of procedure are: how do you file motions? That oral motion to dismiss you made earlier, that wasn't following the rules of procedure. Because you look in the rules of procedure, it's going to tell you how to file a written motion, what it must contain, when it must be filed, how the prosecution must respond. For the trial, there's going to be a whole chapter in the rules of criminal procedure for the trial. It's going to be: how do you pick a jury? How, what's allowed for opening statements? Can you argue in the opening statements? No. Can you outline your case in the opening statements? Yes. These are the rules of procedure. This is what the judge wants. Not, oh, the prosecution is suing my corporation. Once again, that translates as wah, 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 because it's gibberish. It means nothing. It's nonsense.
Correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm
not a trustee. Translation: if I were a trustee for your trust, there would be a conflict of interest. I could not sit as a judge in this case, but we're not going after your trust. Well, frankly, I'm not going after your trust, but the prosecution isn't either. They're going after you. They are prosecuting you. Your trust might protect some of your assets from civil liability, depending on what kind of trust you set up and whether you follow the rules and, yada, yada. We're not going to get into that, because there are ways to even breach a irrevocable trust if fuckery goes on. But you can't set up a trust to shield yourself from prosecution. That's not even contemplated in trust law, in probate law. It's not a thing. It's utter bullshit, complete nonsense, made up gobbledygook sovereign citizen fantasy. Absolute fantasy and lunacy. Lunacy. Ooh, tonight's chicken.
Judge, okay? Ma'am,
Okay, so what?
ma'am,
so
no,
what-
you don't get to quiz me, Miss.
Translation. This isn't a conversation. This isn't a Q&A session. I don't answer questions. The court does not answer questions, has no obligation to. The court may answer questions as a courtesy, but it's under no obligation. And furthermore, if that question is about legal advice, the court can't answer questions. It can't. It can't. You asking the court, well, what are the elements of the crime? The answer to that question is ask your lawyer or look it up. I can't give you legal advice. I can't steer you in the right direction. Do you want me to go to the prosecutor and say, you know what? I found this case that the Michigan Supreme Court just dropped. It's going to really help you. You should take a look at that. You should take a look at that. The court can't do that. The court can't help the prosecutor. The court can't give the prosecutor legal advice. Can't point you in the right direction. It can only point you to the lawyer.
Ma'am, do you know what the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
Translation. The exceptions to the hearsay rule are about half a semester of the evidence course. It's really complicated. There are a lot of exceptions. But there are some things that aren't exceptions. They're not exceptions. They just, within the rule, says these things that should be hearsay are not hearsay. They're not exceptions. They're just not hearsay. It's weird because they actually do differentiate not hearsay, that probably should be hearsay, and exceptions to hearsay. It's weird, but it's a thing. And like I said, it's like half the evidence course. So if you think you are capable of representing yourself, summarize it for me. Summarize this very difficult concept. I bet you can't do it, and you're going to look foolish.
Acceptance of the hearsay. Hold on, I want to write all this down.
I'm sorry. No, I'm asking you. You say you know this stuff. How are you going to represent yourself?
You got
don't even know what.
acceptance of hearsay, sir. I would like to.
Acceptance of hearsay? Acceptance of hearsay. Oh, she can't even listen. She doesn't understand what the judge is saying. But the judge, no, I'm not telling you this to write it down. I'm questioning you. This isn't legal advice. This is questioning your knowledge. I'm not giving you things to write down to help you. She has a fundamental misunderstanding of what's going on, even right here, right now. Not just about the entire proceeding. She doesn't know what the hell is going on right now. She thinks the judge is pointing her in the right direction. No, he's trying to make her realize how little she actually knows so that she takes the lawyer.
To write everything you're saying down so I can
Have
be
you
able
ever
to.
have you ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No, do you know how?
This is painful. Have you ever done jury selection? Yeah, the jury holds 12 people. Non-responsive. That's non-responsive. You're not answering the question. You're not giving the judge confidence.
How to ask them questions and how
Yes,
to do the jury instructions. All right. Do you know how to preserve issues for appeal?
No.
yes,
Do you know that
Do you know how to preserve issues for appeal? Translation. You're almost certainly going to lose. And if you don't preserve issues for appeal, the appeals court is going to laugh you out of that appeals court. They're going to say, Ms. Sovereign Citizen, you didn't preserve this for appeal. It's not in the record. This isn't a appeal de novo. So if it's not in the record, it doesn't exist. Now, the most important translation of all. Well, there's going to be two, but this is the first of the most important translations. Why we are here today.
representation is almost always unwise?
yes,
Did you know that the first day of law school, they tell us that he who represents himself has a fool for client? Do you know?
Translation. You are a fool. That's the easiest translation. That is Judge Slavens calling this defendant a fool. He's doing it nicely in the form of a question, but he's saying, you are a fool. Period.
You know, they tell us that.
yes.
And so what does that tell you if they say he who represents himself has a fool for a client? What's that tell you, ma'am?
Translation. Do you realize that you're a fool?
You know what it tells me?
Yeah,
That
what's
you
that tell
are-
you?
You all operate in trade secret acts. So
Okay.
you
Well,
will be a
that's not true, but okay. Miss Tubbs, would you do brain surgery on yourself?
Why would I do brain surgery on myself?
Yeah, because you'd have a fool for a patient, wouldn't you?
Once again, you're a real big fool. You're not a rocket surgeon. You're not the sharpest crayon in the shed.
Correct.
So why do you think you can do law if you can't do medicine?
Because I go by federal law.
Okay. You understand your
Translation for that mumbled okay. It's gonna be one of these. You go by federal law, but you haven't been charged with federal law. You're charged with a violation of Michigan state law. You arguing federal law will just waste my time and increase your inevitable prison sentence. That's the translation there.
receive no special treatment and you can receive no help from the judge during the trial. You understand that?
I understand.
You understand the prosecutor is an experienced trial lawyer who is unlikely to give the defendant any special consideration. Do you understand that?
Translation. The prosecutor is a smart bitch. She knows what she's doing. She is going to mop the floor with you.
Yes,
You understand you'll receive no special help from the court staff and you'll be expected to follow the same requirements that apply to practicing lawyers.
Translation. You know those rules of procedure that I mentioned earlier? Maybe you should look those up, because I'm going to require you to follow them.
Understand that?
Yes.
I mean, he automatically translated that for us. He, you know, it was supposed to, the legalese was supposed to be but he slipped. He slipped. He spoke English instead of legalese and called her dumb instead of saying
Madam Prosecutor, have I complied with MCR 6.005?
Yes, Your Honor.
I assume 6.005 is the state statutory equivalent of the Feretta inquiry.
All right, ma'am, do you believe that your waiver of an attorney is knowingly, intelligently, and voluntarily made?
Correct.
Translation. You don't have some jailhouse lawyer telling you to do this, do you? Your bunkie isn't saying, if you get a lawyer, you're getting shivved tonight.
And accurately and understandably?
Yes.
Okay. Then the court will find that the waiver is knowingly, intelligently, voluntarily made. The waiver is unequivocal. You understand the disadvantages of self-representation, and self-representation will not disrupt, unduly inconvenience, or burden the court. So I'm going to grant.
Translation. I don't find you intelligent. I do think you're going to disrupt, but you answered just barely well enough to comply with the rules so that I have to let you represent yourself, because barring some other reason, you do have that right.
Grant your request to represent yourself, ma'am, okay?
Thank you.
All right. Now we've got a jury trial. What's our date?
And I would like the full discovery package sent to me, please, as well with along with the Dr. Chef report.
The Dr. Chef report. Now, her attorney already has the discovery. So, frankly, he just needs to forward the discovery packet to her. She might have trouble accessing some of it because, technology, and she's in jail. But if discovery hasn't been presented already, this isn't how you request discovery. You put a motion on the file, a request. You say, in writing, you say, yo, prosecutor, I want all of the discovery. I want all the Brady material. I want all the exculpatory material. I want your witness list. I want everything. Why don't you throw in the kitchen sink while you're at it? You don't go into court and say, I'd like discovery right here, right now.
And the oath of office, please, so I can know what I'm dealing with.
All right.
Do you guys go by maritime law or common law?
Ma'am, it's not maritime law.
Translation. Bitch, we're not on a boat. This is criminal law.
You need to learn the law, okay? I'm not advising you on the law. I told you I'm not advising you. If you don't know what it is, that's up to you to find out. I'm not advising you on anything on the law, ma'am.
Don't worry about it. I know what it is.
Yeah, don't ask for any special consideration. You have to perform just as any licensed attorney would here. So,
translation. No, you don't know what it is. And I'm not going to tell you, because you have to figure it out. You are representing yourself.
If you don't know that, I would strongly recommend you have an attorney represent you if you don't even know if it's a maritime law or
It's,
not.
it's my right to ask questions.
All right,
'Cause
well,
you-
go ahead.
It's not. Translation for okay, go ahead. It's not. It is not your right to ask questions of the court. You can ask your attorney. Of course, your attorney can say, you know what? You're wasting time. You are asking these questions in bad faith. But the court does not have to allow you to ask questions. This isn't an open forum. The judge is in charge of the court. And you have absolutely no right outside of, when's the next court date for the judge to answer your questions.
As I said, he who represents himself, he or she is a fool for a client, ma'am.
Okay, translation. You're an even bigger fool than I thought.
Okay. We will have the attorney send you those documents. Madam Clerk, if you can get a standby counsel for this for March 17th at 9 o'clock. Is there anything else we need to take up?
So am I here released?
Yes, you're released.
Thank you, Your Honor.
Your Honor,
You need to send
Translation from the now former defense attorney. I'm free. Dobby has a sock. I can go. I don't have to deal with this circus anymore. Huzzah.
all the materials to her. And also, if we can get her brought here from the jail, Madam Clerk. Okay,
that's what I was going to ask for, is to have her written here and then another date before the trial date where standby and Miss Tubbs would be here,
Today.
where we would all be on the same page.
well, we're gonna get the standby.
That was today, but spoiler alert, she was on Zoom, which caused problems, kind of. That's why the video is so long for so little content.
And do that right away, as soon as we get that.
Okay.
I
We can
request that,
schedule this for, ma'am, don't interrupt me. I don't interrupt you, you don't interrupt me.
Translation. I'm in charge. Speak when you're spoken to. It's that simple.
We'll schedule this for February 19th at 9 o'clock for assignment of a standby counsel, okay? And if you can make sure that she is on Zoom that day, Madam Clerk? Okay. Is there anything else we need to take up with regard to Ms. Tubbs' case? And you, ma'am, just so it's clear, you're under oath, you are requesting that there not be an insanity defense. Is that correct?
That's correct. And I also,
Okay.
February 19th,
Madam
I
Clerk,
have
if you can
something
prepare,
scheduled at 9.
ma'am, don't interrupt me.
Hold on.
Prepare an order that says that she's withdrawing any insanity defense. Okay?
Oh, okay. So February 19th was the sentencing in the other case, which is why they moved it to the 20th. I keep saying today, it's past midnight now, but I'm still awake, so it's still today.
All right, what, Ms. Tubbs?
I have another court time at 9 a.m. on February 19th.
All right, then we'll make this February 20th at 9 o'clock, all right?
Thank you.
All right, anything else we need to take up?
No, Your Honor.
All right, nothing further, this matter is completed, everybody have a great day.
So does anyone think that Quinice Jones on Zoom there, do you think her parents were a fan of Quincy Jones? You know, they're in the area of Motown, you know. So today's hearing, basically they got the Ms. Portillo appointed as standby counsel. She was there in her car. Ms. Tubbs was on Zoom from the jail. And so they put her in a breakout room with the prosecutor and standby counsel so they could discuss resolution potentially. It's not resolved, it's going to trial. But the only thing that needed translation in that is basically the prosecutor said, I'm not going into a breakout room with just the defendant. I'm going either with the standby attorney and defendant or not at all. And the defendant said, well, fine, the standby attorney can go in since the prosecutor's, she's scared of going in with me alone. She's afraid of the truth I'm gonna say, essentially. Now, here's the translation of the prosecutor. Your Honor, I am not going in the breakout room alone with the defendant because, number one, I want a witness in there in case she makes admissions because I don't want to become a witness myself. So, frankly, she actually should have had a paralegal from her own office in the Zoom with her because the paralegal still covered by attorney-client privilege, can't go blabbing. It's part of the paralegal's job, but or have an investigator or someone, a third party who the prosecutor can waive any privilege and and put them on the stand if the defendant makes admissions. But number two, it's not that she's afraid of what Ms. Tubbs is going to say in the breakout room. She's protecting herself against false accusations from Ms. Tubbs. She doesn't want Ms. Tubbs to come back to court and say, yeah, the prosecutor, she just admitted this is all bullshit. The prosecutor committed this crime on, the prosecutor wants to have a witness in there to say, Your Honor, that's made up. I was there too. It didn't happen. This is what was discussed. They discussed resolution of the case. Ms. Tubbs was not amenable to resolution. So the prosecutor wants to take it to trial. The prosecutor does not want to be a witness. That's why. It's not because she's scared. It's because she doesn't want to be a witness. She wants to be a prosecutor. So I hope you've all enjoyed that peek behind the curtain. I hope you appreciate the risk I took giving you that peek because they're gonna come after me. But my conscience just, I had to do it. So please like, share, subscribe, do all the YouTube-y things, and I'll see you next time because I've got another one I'm gonna do. I thought I might record it back to back today and then release them 2 days in a row, but I'm a chatty guy, and this took longer than I intended, but hopefully you enjoyed it. So I'll be back with another Sovereign Citizen very soon. So have a good one. Do all the YouTube-y things. I'll see you next time. Bye-bye.